So my name's Liz Pollard. I'm a solicitor with Shentons Solicitors in Winchester. I'm going to talk to you about powers of attorney and deputyship, which is probably not something you've come across until this sort of stage in your lives and your children's lives. This is sort of aimed at the young people in the hope that they might, in their transition to adulthood, be able to make power of attorney, and then if not, I'm going to talk about what the options are instead. So when your young adult reaches 18, they suddenly become responsible for their own financial affairs. And up until now, as parents, you've been managing it for them. So as a young adult, they start to take on responsibility for their own money. So when we talk about financial affairs, we mean things like their bank account, their savings, any inheritance they've already received, and their state benefits. When you're under 18, your parents manage your money on your behalf, but once you reach 18, your authority as parents ceases. And you can continue to do it informally, but it's whether you need a formal structure to help them. If your young adult hasn't got significant financial affairs, it may be that you don't need any formal structure. So although you're hearing the words power of attorney for your young adult, it might be that you don't need a power of attorney or deputyship or anything formal in place. It might be that you can continue as their appointee with the benefits agency and still continue to claim all their benefits on their behalf. It might be the benefits agency insists now that the money goes into a bank account in their name rather than your bank account. And if that's the case, you can open a bank account in their name, but you can also have your name on that account. It can either be a joint account or you can be on as a nominee. So there are ways where you can continue to help your young adult informally. If they have got significant financial affairs and they can give us decisions about who they might want to appoint themselves to help them, they might be able to manage their financial affairs largely themselves. Now, obviously, that depends on the individual. It may be they've got the capacity to manage all their financial affairs themselves, particularly if their financial affairs are not complicated. Or it may be that their mental capacity fluctuates depending upon their condition or their diagnosis, and it might be that power of attorney would be useful so that you can give them some support in managing their financial affairs. Or mental capacity, as we know, is on a decision basis. So it might be they've got the capacity to manage their own bank account, have their own bank account with a card with a modest amount of money in it. But it might be that for the more complicated side of their financial affairs, they can't cope with that and they might need you as parents or another adult to help them with all of that. So who decides if someone's got capacity? I'm sure you've come across it already. It would be, good luck with the GP, it would be their consultant or their specialist, because obviously GPs are just overworked and you don't always, unfortunately, get much assistance from them on the capacity side of things. Even if you've got capacity to manage your own financial affairs, you might want the support of others, and that's where lasting power of attorney can be useful. So if you have a young adult who is capable of giving us instructions to make a power of attorney, once they are approaching 18, this is the time to think about it. And in fact, we say here, they can't actually make it until they're over 18. So what's a power of attorney? A power of attorney is a legal document where somebody appoints other people to manage their financial affairs on their behalf. And we see this mostly with elderly people. They start to think, oh no, we want our kids to help us with this now, either because they're losing capacity themselves or just because they can't be bothered with the hassle of it anymore. But obviously with young people too, this can be really helpful. If you've been supporting your young adults through their childhood and managing their money on their behalf, if they've got the ability to make a decision about who they want as their attorneys, we should be able to make a lasting power of attorney for them, and they can choose you or others to manage their financial affairs with them. As attorneys, you've got a duty to consult and empower the young adult to make as many of their own decisions as they can. So a power of attorney doesn't mean that they are giving you carte blanche over their financial affairs. They can still do as much as they can themselves, but you can support them in their decisions. And if it's a decision where they can't make that decision themselves, then you have to act in their best interests. A financial power of attorney, I'm obviously going to say, oh, use a lawyer, but actually you can do it online. There's a good government website and you can make a financial power of attorney online. So if you've got a young adult who's astute with tech and understands how websites and things work, then you might have the ability to do it online, but otherwise a lawyer can help you. They've got to be over 18 before they can sign the document. And they can choose anybody to be their attorneys, so they can choose parents or others who can help, and you can have an attorney, and then you can also have replacement attorneys, so people perhaps of a younger generation who might be able to step in and help later on. And you would need perhaps a professional capacity assessment to make sure that you have the ability, that your young adult has the ability to make a decision about who to appoint as attorneys. So what happens if you have a young adult who isn't in a position to make a lasting power of attorney? They haven't got the capacity to understand when we explain to them what it is, and so they can't sign the document. If that's the case, and you're deemed not to have capacity to make a power of attorney, then the people supporting the young adult, so you guys, the parents or those who work with them, can make an application for a deputyship order. Those wanting to apply have got to complete COP forms. Now again, you can do this online, but these forms are not as user-friendly as the powers of attorney forms, and you probably would want a bit of support to do all of this. There are different kinds of deputyship orders that you can apply for. We're talking about financial at the moment, and you can have power to administer your young person's financial affairs wholly, all of their financial affairs on their behalf, if there's no prospect that they can deal with their own financial affairs themselves. Or you can have a specific decision from the Court of Protection just to manage one particular thing on their behalf, if they can cope with other things themselves. We have to serve notice on the young person, all of those people who are related to them, who are interested in their care, and any professionals who have regular contact with them, so that they can confirm that they're happy to the court who's applying for deputyship. So it's a bit of a process. Deputyship, as we've said before, is only required if the young person has significant financial affairs. If their only assets are their benefits, then they can appoint you or somebody else to be their appointee with the benefits agency, or you can apply to be appointed their appointee at the benefits agency, and you can arrange for their benefits to go into a bank account that you can still access it. It might be in their name, but you can still access it. So it might be that you don't need a formal legal structure. It's only if they've got significant savings. So if, for example, they've already inherited money and you need to be able to access that money on their behalf, or perhaps protect that money from them doing something a bit silly with it, perhaps they're vulnerable and they give it out to all their friends. So in that situation, you might want a deputyship order. And speaking of inheritance, it would be helpful if you could consider perhaps not allowing a young adult with learning disabilities who can't manage their own affairs from inheriting directly. There's different kinds of trusts that you can have instead. Discretionary trusts and disabled persons trusts, and grandparents and anybody else in the family, rather than giving that money to the young person. Perhaps it could be protected within a trust instead, and then the trustees would operate that money, and again, still no need for deputyship because the young person doesn't have the money in their name, it belongs to the trust. Just to give you an idea of costs and what solicitors charge, this is us. I think other firms are pretty similar as well. So one straightforward power of attorney is £500 plus VAT, two £750 plus VAT, and then there's possible extra charges if we need a bit longer with them than with the usual. There's an £82 registration fee. If you go online and you do this online directly with the OPG, they only charge the registration fee. And then if we're looking at deputyship, unfortunately, it's a bit more expensive. We're looking at between £2,000 and £3,000 for a deputyship order with a lawyer. So again, back to the whole, if you need financial deputyship, it must be because there is money in that individual's name, and so hopefully that money would pay those costs. There's a court fee for that, £371. Deputyship is taking between a year and 18 months at the moment for a financial deputyship. Powers of attorney are taking 6 months to register, so there is a bit of a delay with the two organisations, the Office of the Public Guardian and the Court of Protection. Okay, so we've been talking about financial, so we've talked about financial powers of attorney, financial deputyship, but health and care is also a thing. You can have the legal authority to make health and care decisions for somebody else on their behalf. If they understand and they have capacity, they can make a lasting power of attorney under which they can appoint other people to make their health and care decisions for them. If they don't understand and they need somebody to make health and care decisions on their behalf, then you can apply for deputyship order for health and care. The Court of Protection are much less excited about health and care deputyship orders. They don't grant them as often. They like them on a decision by decision basis rather than a full carte blanche over somebody's health and care decisions for the rest of their life. But it obviously very much depends upon somebody's diagnosis and their prognosis. If there's no possibility that the young person would be able to ever make health and care decisions on their own behalf, then it is possible to get a health and care deputyship order. What do you do if you haven't got one? Health and care decisions are supposed to be a collaborative process under the Mental Capacity Act between the person who needs the health care treatment, the people who care about them, so their family, and the professionals who are involved with them. So if you've got a young person who's not able to consent to hospital or medical treatment, it should be that those around them are able to reach that decision on their behalf. If you're having a situation where you've got medical professionals or other professionals who perhaps want to go down one route, and you as parents or as people who care for this young person think that a different route would be better, you can ask for something called a best interest meeting within the legislation, and then hopefully reach a cohesive way, everybody can agree a way forward. That's not obviously the case, and sometimes we hear, you get quite often these high profile cases about turning off life-sustaining treatment where the doctors want to and the parents don't want to because they think there's a possibility of recovery. Hugely emotive situation that, and that's where the court would get involved at the most extreme end. We're not talking about that kind of thing today. Health and care decisions are the things like where you would live, what your daily routine might be, what medical care you might receive, and it may be that your young person can make decisions about certain aspects of what they do during their day and what food they like and what have you. So it might be that you wouldn't need necessarily to be so closely involved in those decisions. And then if you lack capacity, if your young person lacks capacity, then there's the opportunity to apply for a deputyship order for health and care. And again, it's a question of filling in the forms with the court protection, and as I say, they're a bit onerous, and getting a doctor's opinion as well, that the person lacks the capacity.
I'm Hannah Adams. I'm a special education needs solicitor, and I work at Shentons. Just as a little bit of a background about me, I'm also the mum of 3 children, one of whom has complex and significant special educational needs and a disability. So I've traversed this journey as a parent as well as a lawyer, and I've been specialising in this area of law now for the past 10 years. So the kind of work that I do at Shentons on behalf of families, parents and young people themselves are usually where cases are quite complex. So I think the advice that I'm giving you may be a little bit more steered towards the more complex end of need, as opposed to those of you who may have sat in on the Sendias talk earlier, which was a bit more broad, but there will be some overlap from what she spoke about as well, that lady. So what we're going to cover is just to understand what your rights are and the rights of your young person are as they reach the age of majority in relation to their education. What post-16 support can look like, because it can look very different from perhaps our preconceptions of what a mainstream post-16 education looks like, A-level, sixth form, college or whatever. It's much broader than that. And it's to look at the local authority's responsibilities to your young person. And we're going to touch on the cease to maintain notices and social care and healthcare aspects of the EHCP as well. The EHCP can last up until a young person is 25. So it's really important that you're aware of that and that your young person is. And as long as you can evidence a need, an ongoing need for education and training, or training for your young person, then if they have any HCP to support them, that should continue. So it's important, it's really important to start the thought process of transition and post-16 and post-18 education much earlier than you think. So what the law says is that it should be formally considered from the Year 9 annual review. So when you have an education, health and care plan, it is reviewed annually by your educational setting, and they consider and plan for the year ahead and discuss whether there are any amendments that are required. So from when your child is in Year 9, that should include looking ahead to what their post-16 trajectory is going to look like. And that includes you as a parent and them as a young person if they're they are, to the degree that they can be involved, asking and trying to establish with the current provision what their trajectory is going to look like. What do we feel is going to be realistic, and what does the young person want themselves in relation to their study. And it's important to remember that legally all young people now are required to be in full-time educational training until they're 18. So there needs to be provision and planning made for that post-16 gap, if you like. So what can post-16 provision look like for young people with disabilities and special educational needs? So it can look like your mainstream college option, and there are plenty of those around, and a lot of them are increasingly expanding to provide reasonable adjustments and additional settings for people who've got additional needs and special educational needs. But it can also be A-levels and various different new qualifications, which I'm not even going to profess to know about all of, because there are so many of them. But that can be available in a mainstream college. Sometimes that is, in your larger classes, the usual classes of 30 or whatever they are, but sometimes it can be an additional separate unit, which is there particularly to have smaller classes for young people with additional needs. Post-16 provision may, for your young person, really be centering on the development of independent living skills and what are sometimes referred to as life skills courses or functional skills courses. So just because your young person isn't very academic and accessing academic subjects doesn't mean that they don't still have a need for ongoing education and training. It's looking at what that means for your individual young person, and ensuring that that is reflected in the EHCP. It also, post-16 provision can include specialist provision. So really, when we're talking about that, we're looking at the independent special sector, because the maintained sector generally doesn't have specialist post-16 provision unless it's attached to one of their already maintained special schools up to 18. So it's important to understand that if that is what your child's needs require in terms of the provision to meet those needs, that you can look at those options and ask for them to be named in the EHCP. And that can include residential specialist provision. So for young people whose one of their key targets is to learn those independent living skills that they're going to need to be explicitly taught and modelled, residential provision allows an extended curriculum which goes across your college day, but also into a residential setting where they are learning to generalise those skills and putting them into action, learning to live alongside other young people. Post-16 provision can include apprenticeships and supported internships and other further education options where the young person requires a significant amount of support. So it's important to be aware of that, so that when you are talking about your young person's trajectory and study path, that you are aware that the EHCP can continue in the same way that it has done through their secondary education. So as you come up to the end of year 11, and you're looking at your post-16 placements, the local authority, and you've got an EHCP, the local authority have a legal responsibility to amend the name of the provision in section I by the 15th of March in the year of transfer. So you'll probably be aware of the secondary school transfer deadline, which is when the child is in year 6, and that's the 15th of February. And what it means in terms of post-16 provision is that local authorities are always incredibly busy and usually still dealing with a massive backlog of secondary school transitions. So what's really important to remember about this is that although the local authority must amend the EHCP by the 15th of March, they don't have to wait until that date to do it. So you can be asking and planning, and you need to be much earlier in the process. So, in your autumn term, as you go into year 11, be having your transition annual review and requesting and having already started the research about what kind of placement feels and looks right during year 10, so that you are then ready to have that annual review in the autumn term, making sure that your current provision calls that EHCP in plenty of time to go through the process. Because, as you may have heard the other lady from Sendias explain, there is a current delay in the Senate Tribunal listing cases for hearing at around the 50-week point. So it's very, very difficult as parents to manage that situation, because if you know that it's highly likely that the placement that you're going to request is going to be refused, then you have a right of appeal against that decision to the Senate Tribunal. And it's important that you utilise that, because that is your only way of getting that decision changed. But it's just, you need to be really aware of how long that process is taking at the moment. And asking your local authority to make that decision earlier than the 15th of March, essentially is the message there. Okay, so what can quite often happen with young people who have had an EHCP is that the local authority will take a view at key transition points that actually they can save some money by ceasing to maintain that EHCP. They would probably couch it in terms of, this young person has done so well, they no longer need the provision set out in the EHCP. They're moving on from a school setting into a post-16 setting, and therefore, there is no need for that support. And it's just really important for you as parents to be aware, and for your young person to be aware, that actually they do still have a right to that special educational provision if that is what they need. And so it's going to be looking very carefully in the transition reviews and the annual reviews from year 9 about the outcomes that are in section E of your EHCP, and making sure that they are updated, so that you don't end up in a situation where the local authority turns around and says, well, look, all of these outcomes have been met, so there's no need for this provision to be continued, etc. So to be on that, and to be realistically reviewing those to make sure that your EHCP is in a good working order. And if the local authority comes to the transition review, well, after the transition review is held, the local authority make a decision that they're going to cease to maintain that EHCP, they must write to you and give you a notice that states that, and you will have a right of appeal against that decision. And that's really important, because the local authority must maintain that EHCP if you appeal. They must maintain it up until the point when the tribunal makes a decision on the appeal, which of course, given the timescales, could be a year in advance, and in the meantime they must be delivering provision for your young person. Okay, as per the EHCP. So the other important thing to know about the Senate Tribunal process is that when a young person turns the age of 16, the right of appeal actually passes to that young person themselves. Up until that point, the right of appeal would belong to you as parents. Now, when this new law came in, we were all a little bit baffled as lawyers about how that was going to work, because essentially a young person at 16 who is going to be utilising a right of appeal against the contents of their EHCP has got significant needs by the dint of the fact that they require that EHCP in the first place, and are likely to find that whole process very anxiety-provoking, even if they do have the mental capacity to understand the litigation, the legal proceedings, and understand legal advice. So, but this all comes down to looking at capacity for that young person. And even if the young person does have some mental capacity to understand that process, parents can support them through that and assist them with the paperwork. And essentially, if they don't have capacity, we'll look at, potentially having to provide evidence about that, then the right of appeal will remain with the parents, and the parents can exercise that on their behalf. But it's important to understand that, because some young people will want to be involved in that process, and as solicitors in this area, we are very well versed in acting jointly for young people themselves, helping them have a voice, facilitating that, but also acting together with the parents. So it's usually a family affair, if not just the parents. but it's important for you to understand that that's what happens at 16. Okay, so the EHCP also has sections in relation to health and social care. You may not have access to social care for your young person up until the age that they reach 16. But I think the important thing about this aspect to consider really is that all young people of that age have a right to live as independently as possible and to go out independently and not to have to be with their parents to rely on them for their social care. So if there is an aspect of young people still needing a lot of assistance from you in their daily living skills, in their ability to go out into the community by themselves, that is when you need to start looking at what social care can provide by way of support. And the idea behind the EHCP is that those social care needs are set out in section D, and that provision for social care to meet those needs is set out in section H. Now, those sections as standalone sections are not legally enforceable. So if you don't like the contents of sections D and H in your EHCP and you're unhappy with that, you don't have a right of appeal against those sections to the Centre Tribunal. But if you are appealing the education content of your plan, you can ask the Tribunal for what's called non-binding recommendations about the contents of the social care and health sections of your plan. So that is when we lodge what is called extended appeals with the Centre Tribunal. So you're asking them to make decisions about the education contents, but you're also asking them to give recommendations about the social care. And although those are non-binding, the public body, social care or healthcare, have to go away and consider the recommendations of the tribunal. They have to give detailed reasons as to why they're going to depart from those recommendations if they are saying they're not going to follow them. And potentially then you have a right to a complaint through the local government social care ombudsman, and you can also get legal advice about potential judicial review if you think that that is unlawful, the decisions that they're making. And that really is where you do need legal advice around that. But it's just important to understand when you're looking at your EHCP at the post-16 provision to consider the potential social care element. I think it's quite common for us as parents to have managed the needs of our child in such a way for so long that we don't appreciate how much we're actually doing and how much of a kind of propping up role we are providing. And you do need to think about what happens if and when I am not there in the future, and look at their again their trajectory of development, how they're coming along. They may get those skills in time, but it may take them a lot longer than other young people. And in the meantime, they have a right to social care and to be supported when they're going out and about, and in all sorts of different ways. And the other, so you can ask children's services before they are 18 to undertake an assessment of your child's needs. And you can also ask for an assessment, for them to do an assessment of your needs as carers of that young person. And all of that information then should be incorporated into the EHCP. So when the young person turns 18, there is a duty on children's services, social services, so care services, to do an assessment of their needs if they think that they are going to require support and that they may be eligible. And eligibility is around them having a disability and additional needs. And a care needs assessment can be requested by the young person or parents, and that really needs to be in the pipeline before you're getting to that stage. So in the kind of post-16 to 18 period of time. And the carers assessment of you as parent carers must be considering whether or not you are able to, unlikely to be able to continue to deliver the level of care that you have been giving that young person when they were in their minority into their majority. And it's also looking at whether or not you wish to continue delivering that caring role, because that isn't what is envisaged in in life when we have our children, we expect they will reach the age of majority and they will get some independence from us. And therefore, your circumstances may be such in terms of your health and your ability to deliver that care that actually that isn't something that you feel you can continue to do. And the whole purpose of the care needs assessment is to look at that and to take that into consideration and to consider to what extent provision of support can contribute to achieving the outcomes that you want as a parent carer. So if you want them to achieve independent living, whatever that looks like for them, that may be supported living, it may be in a care home, care placement, then that is what they need to be assessing, and you need to be aware that they have a legal duty to do that. So for some young people, and I'm talking really at the more kind of complex end of the spectrum, there will be young people who have very significant and ongoing long-term health conditions. So that may be physical disabilities, it can be requiring breathing support or medical management, particularly if they are going to lack capacity to be able to do that for themselves. There may be a need for what is called continuing health care from the NHS. And that is, you can make a request for the NHS to do a continuing healthcare assessment. And essentially what that means is they will look at how much of the care that is required for that young person relates to their complex health needs. And it's a divvying up of the pot of money that will go towards funding their care, their social care, between social care and between health. But that's really for young people who have got very complex presentations and are going to need a lot of medical management and care, as well as their social care. So that has been a bit of a kind of whistle-stop tour. I feel like I went really, really fast. It's also very much geared towards a young person who has an education, health and care plan. The other thing I just wanted to say about that is, that is what I deal with, because mostly people come to a solicitor when they've got quite complex cases and they really need a lot of help. But what I see quite often, and I do a pro bono, a free legal advice clinic for ReMinds on a monthly basis, and what I see coming up is young people who perhaps have had late diagnosis, particularly of autistic spectrum condition, or mental health difficulties and conditions that emerge arising out of that during their secondary school education, and the EHCP has never been applied for, or hasn't been put in place, or it's coming really, really late. If that is you and those are your circumstances, you've got to remember that you can request an EHC needs assessment for your young person, and they can request it for themselves at any age up until the age of 25, as long as they've got special educational needs which require further assessment and may need provision delivered to them by way of an EHCP. You can request that. So I think there's a tendency for parents to feel like, well, we're in year 10 now, and it's all horribly too late, and it's all gone Pete Tom. And I appreciate, particularly as a parent, that's a really difficult position to be in. It's really, really scary. But actually, there is no legal cut-off for that. And more and more, as a country, I guess, and the legislation is encouraging us all to think about learning as a longer process. It's not just about those very traditional stages of 16, we leave school, we either get a job or we go to sixth form college. It's not like that anymore, and education and training looks very, very different for different young people, and therefore it doesn't mean that they're not going to need the support of an EHCP, even if it hasn't been actioned up until that point. So that's another point to consider, really. Okay, so that's kind of all of our information. I hope that has been helpful, and yeah, just don't forget that we do have that monthly free legal advice clinic. So I offer half an hour to families over Teams that you can access through ReMinds.
Thank you very much.